Good afternoon. Good afternoon. Like, share, subscribe, share the video. I do need some likes, but Young Thug, if he don't come home, outcome of this case, he is definitely coming home on appeal. They have violated all kind of his constitutional rights with his attorney and the attorney's defense team. I mean, I never seen anything like it. They got a hostile witness up there, Copeland, who is being coerced, and he told them that Copeland told him that if he go up there he will lie, and they don't care that he would go up there and lie. He confessed to a murder, and they still gave him immunity and said we're not going to charge you with that murder. And he getting up there acting a fool. He has not really given them any information, and he is the star witness. Every minute of the day that he's there, he is surrounded by the prosecution, the police, and the judge. Now, I really don't have a problem with because he is the prosecution's witness, but the police presence as Young Thug's attorney Brian Steele. I mean, I ain't never seen nothing like it. It is something that it's buffoonery. That's what you call it. It is buffoonery, and it's actually embarrassing for black folk. It really, really is. It really is embarrassing. But I'm gonna let this video play because he breaks this down about that trial, and it's a must watch. But be prepared to be embarrassed.
What's up, everybody? And welcome back in as we are breaking down a motion to recuse the judge in the YS trial in Georgia. After all the shenanigans going on, one of the lawyers has filed a very detailed motion to recuse that judge where we find out details of what happened in this secret ex parte meeting with the judge, the prosecutor, and a witness that was already sworn in. I'm going to bring my dad on. We're going to talk about what's unusual about this, what this says about the judge and the system that's going on there, and what we think is going to happen next. All right, so we are going to start with the motion itself, which is a motion to recuse the chief judge. And by the way, while we're talking about this, we might as well mention this witness, Mr. Copeland, has been testifying. It has been wild. He has been telling them that he's just saying yes to get it over with. He has been refusing to answer.
Wild is an understatement. This courtroom has been buffoonery at its finest. I'm just saying. It is unreal. But this is the paperwork because the glare of the sun in this daylight, you can't really see it. So
some of their questions. He has been doing all sorts of things that you hate to see as a lawyer on the stand. And that's going to give a little bit of context. They have continued with the trial. They have a lot of breaks, which is important as we dig into this. But anything you want to mention as to what's going on in the trial before we read this?
Well, he doesn't remember a lot.
Yeah.
He doesn't remember a lot. No, he don't. He don't recall nothing.
Normally, when we would give somebody a mute,
Oh, shoot.
Fallout over Sean Diddy Combs.
What's up?
But I don't blame him because it happened in 2015. And like he sat up on the stand, he said he can't remember what he did yesterday. Complete fool. He is making the prosecution look really, really bad. And I would have pulled him off of that because he is not helpful. You got a dozen other people to call. And this has been 7 months of buffoonery.
Halted until the present motion is heard by another judge of the Superior Court, consistent with the uniform rules of the Superior Courts of the state of Georgia, stating the following. It is vital to the functioning of the courts that the public believe in the absolute integrity and impartiality of its judges. and judicial recusal serves as a linchpin for the underlying proposition that a court should be fair and impartial. The present case involves 60 legal indictment against 28 individuals. Jury selection in this case began in January of 23, presented less than half of its current witness list. And again, that it started in November of 23, so that's 7 months ago. And they've only presented half of their witness list. Now, sometimes they don't present all the witness list, but that is saying something. The trial should last well into 2025. The 6 defendants presently on trial, 6 out of 28, including Mr. Kendrick, have been denied bond and incarcerated for over 2 years. A central figure, perhaps the central figure in the state's case, is Kenneth Copeland. That's the witness we referenced off the jump. On Friday, June 7, 2024, Kenneth Copeland was sworn in. Despite being warned by Chief Judge Glanville that incarceration may be the result of refusing to testify after being given a grant of immunity, Copeland refused to testify on that day. We watched a lot of that together, and that's what spun into Steele ending up finding about this ex parte meeting that happened afterwards and eventually thrown in jail.
Right.
Copeland was ordered to be incarcerated by Chief Judge Glanville on that date, and Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th at 8:30, where Copeland would announce whether or not he was prepared to testify. On June 10th, all defense counsel were present in Fulton County Courthouse around 8:30, admitted entrance into courtroom 1C and seated by 9 a.m. Defense counsel waited and waited. Between 11 and 11:30, Glanville took the bench and announced that Copeland was prepared to testify. I mean, that should have been a surprise to all of them because they didn't know what he was going to do. They were supposed to be there at 8:30 and nobody really shows up till 11:30. Brian Steele, counsel for Mr. Williams, inquired with the court as to the delay to the chief judge taking the bench. His inquiry was not accepted. What do you think about that? I mean, that's a pretty big deal right there that they asked about it and the judge would not even take it under advisement at that point.
Well,
You can't make this up. You can't make it up.
And he thought they would. He thought they wouldn't find out. And wrong he was. But he thought they wouldn't find out, so he figured he could just brush it off and move on.
Unknown to any member of defense counsel during the waiting period in the morning upon information and belief. You're going to see upon information and belief a lot. That's like them saying, I know, but I can't tell you how I know. Or I think I know, but I'm not sure.
Well, it's also a way of saying this is not my personal knowledge, but I got it from somewhere else.
Right. An ex parte meeting was held in Chief Judge Glanville's chambers on June 10, 2024. Among Chief Judge Glanville, ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witness Kenneth Copeland, and Copeland's attorney. And he's citing the affidavit, which we'll read at the end. No members of defense counsel was present at the ex parte meeting, despite the subject matter of the meeting being a critical phase of the trial. We'll get the definition of that later. Upon information and belief, neither Judge Glanville nor any member of the court staff nor the Fulton County DA office made any member of the defense counsel of all the defendants aware of the ex parte meeting, either before the ex parte meeting was held, during the ex parte meeting, or after the ex parte meeting. Copeland briefly testified prior to a lunch recess. One or more members of defense counsel were later made aware of the ex parte meeting with sworn witness Copeland and made aware of at least some of the content and subject matter of the ex parte meeting. So these are only some of the details, and they were made aware, but they're not telling us how they were made aware. Upon information and belief, the following events occurred at the ex parte meeting with sworn witness Copeland in the chambers of Chief Judge Glanville. So these are the highlights, but like I said, we're going to read the whole affidavit at the end. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment rights and not testify. Why is that important? If they found
Right. So he was going to invoke his Fifth Amendment rights, and he did get on the stand, and he did say, I plead the Fifth, which will make it where the defense will not be able to question him when you invoke your Fifth Amendment rights. He is a hostile witness. He told them he would be willing to sit in jail and do the 2 years. He is not giving them what they want. It's awful. It's awful. It's so sad for Black folk. I mean, really. And these supposed to be professional Black folk at that.
found out right before he took the stand?
Well, because they want to cross-examine it.
The defense wants to cross-examine him.
Right, and they don't have this. They're not going to have this information to cross-examine him. Although that's changed.
Well, not just that, but regardless of what the defense wants to do, if the state knows it, they should have been able to put him on. I'm not going to read upon information and belief every time. Copeland stated that he would sit in jail for 2 years. Glanfield were tried, not just the 6 defendants in trial now. So until 2025, which is this whole trial, then when they can try the remainder, whoever else ends up going to trial, he's just going to have to sit there the whole time. That's the threat.
Let me stop for a second.
Okay.
The next one you're going to read.
That is coercion. That is awful. That's all.
The one thing I was looking for, they don't say that they were made in the presence of the judge. I think that was interesting, and I don't know if it's on purpose or not.
Well, they don't say they weren't, and they did say among the people there were the judge, the ADAs, and the witness. So if he wasn't, if something changed, I would think they would put that in there, but I don't know. ADA Love and Hilton informed Copeland that there were over a dozen defendants left to try. Upon information belief, following the above coercive actions by Chief Judge Glanville, in conjunction with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte meeting that he would testify. So at first he pled the fifth, which is important because then they can't call him. Number 2, he gets these threats. Number 3, he changes his mind. Do you consider that coercive, or is that appropriate for a judge to do?
That's coercive.
Yeah,
that's what I was going to say. So
exactly.
Would you consider it coercive if the defense was there, or is that appropriate pressure put on a judge for somebody to testify?
Well, if they were there, they would have the opportunity to object to the way the judge
exactly
it, and they could have made a record. But because they didn't do that, there is no record, and they have no chance to object to how Granville did it. They could have sat there silent. If they would have done that, then they would have waived their right to object, and therefore they couldn't object because they didn't say anything. But because they weren't there, they never had the opportunity to object.
And the important thing there is they have to have the opportunity to fight this, to object, to dig in, and to see, because I think there is an appropriate way to do this, to say, that's fine, sir, if you want to be incarcerated, you've said that, but just so you know, it's not 2 years. I don't know where you got that number. It's just until all the defendants that you might testify to finish testifying. So if that's what you want to do, that's fine. And maybe it's not coercive, but then there's obviously a coercive way to do that. And the way we protect that process is with criminal defense attorneys there able to object and make sure the judge is doing it appropriately.
Right. Like we'll go to the next bullet point and you'll see what he did. And that's not necessarily wrong.
No, he does it, right? And that's the point.
That's wrong with the defense not being there.
Right.
Flat out
exactly.
Wrong, never right. But it could be if the defense agreed to it.
And you've got the DA and you've got the judge basically pushing a witness to testify for the DA. That's problematic. It looks like they're teaming up to force this witness to testify and be a key witness for the state against the defense. And the defense isn't even there to fight.
That's the biggest part of the impropriety of this, or the appearance of the impropriety, is the fact that those two are working together for a witness for the state.
That's what it looks like, at least.
Exactly.
I mean, whether or not that's true, I don't know, but that's surely what it looks like. Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. Sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Problem, because they can't put a witness up that they know is going to lie. That would be unethical. In response to Copeland's statement that he would lie, ADA Hilton stated that
You can't make this up. You cannot make this up. He told them, I'm gonna lie, and he did. He don't remember nothing. It's no way, if I was the prosecution, that I would have had him as a witness at all. I would have pulled him and his immunity. For real. You got other people to go through, and this is your star witness. Welcome home, young thug.
would not prosecute sworn witness Copeland if he were to lie on the stand. That's problematic and just
part. That's the part I was talking about before. Did she say that in front of the judge? Because that would be something if the judge
can put a witness on the stand and a lie. That's committing a fraud on the court, and that's like rules of professional responsibility 101. That you can't do that as a trial lawyer.
It's a crime. I mean, they're conspiring with a witness to commit perjury. They're committing a crime.
And the problem with that is, like, yes, the ADA can choose who to prosecute and who not to prosecute. That's fine. But it doesn't matter. Like, if I'm a lawyer and I'm not the district attorney, I can't file criminal charges. I still can't put a witness up there to lie, and neither can they. Sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. In response to sworn witness Copeland stating that, ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. So why would she do that?
Isn't that crazy? You can't make this, you can't make this. This is some really. This is awful.
Well, the answer is that's bad for their case. So basically, she's threatening to prosecute him if he testifies to something bad for their case. But if he testifies to something good for their case, even if he lies, she won't prosecute him.
Right. Part of the racketeering enterprise acts was this Thomas murder. So they had to have the other people involved in that Thomas murder because that's part of their proof in the racketeering or the homicide.
So, but the really incredibly important part of this is that the judge is putting pressure on the witness to testify. The state is putting pressure, giving him immunity, number one, which can be appropriate, but then telling him they're not going to prosecute him for perjury if he testifies to something that's a lie, unless it's bad for them, a lie that or something that they think is a lie that's bad for them, then they will prosecute for perjury. It's just, it's horrible.
It's so incredible.
It's unbelievable.
If this is true, and we don't have the transcripts, we don't have the recordings, assuming that the defense is going to get that so they can confirm all of this. If this is true, this is absolute corruption. Do you think this is enough for a mistrial just right here?
Yes, it's enough for mistrial. It's enough for somebody to investigate the Fulton County State Attorney's Office. And if this, in fact, happened in chambers, in the presence of that judge, there should be a lot more investigation going on because that's a corrupt system from the bottom to the top.
And it sucks because this case has been going on so long. I get that the judge is probably so annoyed. It's been difficult. And this is why when people wonder, why do we sever cases? It's really hard to try 6 people at the same time, 6 different defense attorneys, RICO charges, a ton of moving parts, a ton of witnesses, months and months and months. I mean, these are the hardest of cases. What a waste of tax dollars if this is a mistrial and they have to do this all over again.
And
exactly.
This trial, if you look through this trial, has got a history of being chaos. That part. Wrong. You have defendants accused of passing drugs to each other during the trial. You have a defendant being stabbed in the jail during the course of the trial. You have drug arrests of lawyers during the course of the trial. Come on, how many things can happen in one trial?
They must have had 100 motions for mistrial throughout the trial too. I mean, it's been crazy. Yeah. During court on the afternoon of June 10th, when one or more of the above allegations were presented to the court by Attorney Steele, Chief Judge denied that one or more of the events above relayed to him were accurate. Okay? The judge must cease to act and must make an immediate determination. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case.
Can I interrupt just for 1 second? Okay. I read the Mundy case.
Okay.
And in the Mundy case, the judge did not recuse himself and did not make those determinations. But in the Mundy case, The court said it was harmless error, and they did not reverse the case. So they went against the defendants, even though the judge didn't do these things. So it's kind of funny, they were citing a case that the defense lost.
So
Exactly.
on what this case stands for.
Well, it's not as strong as they would like it to be.
The present motion for recusal is being timely submitted to the court. The present motion is being filed and presented in the court in a timely manner. Uniform Superior Court Rule 25 governs motions for recusal. Motions to recuse, along with accompanying affidavits, are required to be submitted to the presiding judge not less than 5 days after the affiant learns of the alleged grounds for disqualification. Such submission shall be submitted not later than 10 days prior to the hearing or trial, which is the subject of recusal, unless good cause is shown for failure to meet the time requirements. Given that the most recent incident demanding recusal just occurred on June 10th, a 2-day period elapsing from the incident requiring recusal to the filing of the present motion is good cause. And then the footnote there is USCR 25.1 also reads, in no event shall the motion be allowed to delay the trial or proceeding. And this motion will address the internal conflict between USCR 25.1 and 25.3 in a later portion. So they're saying you have to stop what you're doing, but then you can't stop the trial. They'll deal with that later. Present motion includes a sufficient affidavit demonstrating the need for recusal, an accompanying affidavit by Douglas Weinstein, who's also the lawyer filing this motion, with evidence for recusal, has been filed and is now presented, which fully asserts facts upon which this motion is founded as required by USCR 25.1. A review of the Weinstein affidavit shows that it clearly states facts and reasons for the belief that bias or prejudice exists, as is required by USCR 25.2. The Weinstein affidavit is specific with respect to time, place, persons, and circumstances which demonstrate bias in favor of the state that prevents impartiality in the present case, as required by 25.2. The particulars of the Weinstein affidavit are provided above and need not be presented again here in detail, but lays out alleged actions of Chief Judge Glanville in conjunction with the state with respect to sworn witness Copeland that took place in chambers. Recusal is warranted based on the facts alleged in the Weinstein affidavit. The facts alleged in the Weinstein affidavit must be assumed to be true when deciding whether recusal would be warranted. The details learned by Weinstein upon information and belief, we're not saying how, detail the holding of an improper ex parte hearing, and we're going to read that footnote about why it's improper, conducted with sworn witness Copeland, which violated the constitutional and statutory rights of Kendrick, including the right to due process and fair trial. The ex parte hearing with sworn witness Copeland was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct. I'm going to finish this paragraph, then we'll read the footnote, which assures every person, including persons such as Mr. Kendrick, of a fair hearing. Ex parte communication are presumed to have been an error. So here we go. Georgia Code of Judicial Conduct 2.9. Assuring fair hearings and averting ex parte communications provides: A, judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. So we're going to read some exceptions, but again, as lawyers, we know you cannot do this. I can't just send an email to a judge. I can't just call a judge on the phone, no matter how good of friends I am with them, and say, hey, let me tell you about the Smith case. We're going to file these motions, or I may need some help pressing this witness when we do call them. You can't do that. You just can't do that. Okay, exceptions.
Well,
where circumstances require, ex parte communications are authorized for scheduling, admin purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. I mean, is that spot on to you?
Yes.
I mean, it's almost like a procedural, substantive, and strategic advantage. It's almost all three that they get from forcing this witness and putting all the pressure on this witness to testify, but not just to testify the way they want him to testify.
You can't
That's crazy.
do that.
All right, B, the judge makes provision promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. That sounds exactly like what the defense lawyers were asking for in this case, right?
Exactly what the judge didn't do.
Exactly.
All right, and then Section 2, judges may obtain the advice of a disinterested expert on the law applicable to a proceeding for the court if they give notice to the parties of the person consulted and the substance of the advice and afforded the parties reasonable opportunity to respond. It's not what happened here, but they still didn't. Like, the very important part of this section that you can all see in here is give the parties an opportunity to respond.
Exactly.
And to know what's going on. Notify them. Number 3, adjudicative responsibilities or with other judges, provided the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. Or 4, judges may, with consent of the parties, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. So you notice a common theme there, whether it's to mediate or talk to an expert or talk to staff or whatever it may be. The parties all must be notified and have an opportunity to say their piece and make a record, right?
Right.
I mean, that's like the important part of this rule. Wouldn't you agree? I mean, what are your thoughts after reading it just right there in black and white?
Well, I tell you what, it's better than the Florida rule. It goes into more detail, more requirements for the judge. But the sad thing in this case is it's right on. I mean, this is the chief judge. If the chief judge is not aware of exactly what that rule says, and you've got to wonder about the system in Fulton County.
Well, it definitely seems like he doesn't know. I mean, he definitely seems like
all this under this infamous Fannie Willis. This is her district, and this is what they're doing. This is under Fannie Willis.
He didn't know the difference between civil and criminal contempt either.
No, he didn't. He didn't.
Right? I mean, that's something that came out when Steele's lawyers were in the courtroom.
Right.
All right, let's keep going here. Rule 211A, the revised Georgia Code of Judicial Conduct, says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. The facts must be considered from the perspective of a reasonable person rather than from the perception of interested parties or their lawyer advocates, or from the subjective perspective of the judge whose continued presence in the case is at issue. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. As the Georgia Supreme Court wrote, we need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she has personal bias or prejudice concerning a party or party's lawyer. Defendants were not provided notice of the hearing either before, during, or after, and regardless, defendants should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. I'm going to read what a critical stage is. The next conclusion of all defense counsel from the meeting among Chief Glanville, the state, sworn witness Copeland, was to harass and intimidate the sworn witness into testifying. Given the facts as alleged must be assumed to be true, the Weinstein affidavit is sufficient, and that recusal would be authorized under the alleged facts. Another judge should be assigned to hear the motion to recuse. Wherefore, Mr. Kendrick respectfully submits that the present motion meets all the requirements, and this motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested relief in this motion to recuse, Mr. Kendrick requests that the court make specific factual findings and submit that Chief Judge Glanville should voluntarily recuse himself. Should the court take neither of the above actions, Mr. Kendrick moves this court for a mistrial due to the ongoing bias the court has evidenced in the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial as his constitutional right of due process and under the Sixth Amendment. Should all of the above requests for relief be denied, Mr. Kendrick requests a certificate of immediate review.
Wow.
I'm going to ask you a question, but I want to read this footnote here real quick, because this is the end of it.
Wow.
A critical stage is one in which a defendant's rights may be lost, defense is waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. Would you call this a critical stage?
Yes, I would call it a critical stage, and I would rely on the last phrase, one in which the outcome of the case is substantially affected in some other way. This is a key witness, whether he testifies or doesn't testify, whether you can cross-examine him based on his refusal to testify. Those are things that are critical, and I mean, it falls right into the definition.
And
it makes a difference.
And defendant's rights may be lost, the right to cross-examine. Right? I mean,
Yes.
That's what you always bring up. So, all right, footnote 5. During the course of a trial, there appears to be an internal inconsistency between 25.1 and 25.3. So this is like halt everything, but we can't stop the trial. How do we deal with that? Mr. Kendrick submits that the court can reconcile the intent of these rules by briefly hearing the motion to determine the timelines and sufficiency of the Weinstein affidavit and make the necessary determination without delaying the trial. The court regularly hears motions during the course of the present trial, and this motion is no different. He's heard a million motions. Let's just do one more is basically what the defense says. Not a huge deal there. So before we read the affidavit, my main question to you is, do you think there's any way to continue this trial if Judge Glenfield recused himself? Is that something that's possible?
Yeah, absolutely. I think a mistrial is certainly possible. I think that
It is a mistrial.
I just don't see how he doesn't have another judge review this motion. I just don't see how he can sit there and deny this motion on its own, because I think any reasonable person, again, that's the standard, it's not the lawyers. Any reasonable person from the outside is going to take a look at these facts and say, oh my gosh, this is terrible. And that's enough. Now, the facts don't even have to be true. They can be total lies. But the fact is that those facts raise enough of an issue for a reasonable person that they are going to say to themselves, there's something here and we got to take a look at it.
So, and just to clarify, like, lawyers can't lie in affidavits. Obviously, this is from a lawyer. Like, you have to have a good faith basis for it, and he says he does. But the point and the illustration of your point is they are taken to be true, regardless of how untrue they may seem.
Right.
They are taken to be true for purposes of this.
It's obvious this lawyer wasn't there, so he is repeating what somebody else is telling him. So he's being truthful because he has a basis for the belief, and that is there is a person that's saying this, so there's a basis. And all I'm saying is that even if that person were lying, there's still enough of a basis here, because you've got to say it's true, and then another judge would have a hearing to make a determination whether it's true or false.
And Judge Glanville, in some of the videos we played last time, said, I know somebody must have been in there and was parroting this to you, or you were eavesdropping, which I think gives a little bit of credence to some of what these defense attorneys are saying.
Exactly.
Because he's not saying you guys weren't there. Somebody lied to
Exactly.
you. That didn't happen. It seems like they're spot on, and that's what's ticking them off.
Well, there's something really funny going on. Let's go through. You want to go through the affidavit first, and then we'll talk about that?
Sure. Let's go through the affidavit first, then we'll talk about what's going on. So sworn witness Kenneth Copeland had been held in civil contempt of court on June 7th for refusing to testify on the date after being given a grant of immunity by Glanville, who's presiding over the case. He instructed the witness and all parties on June 7th that Copeland would be jailed and returned on June 10th. Upon information and belief, defense counsel were all present at the courthouse at 8:30. They all walked in at 9. Then they have this ex parte meeting that the defense attorneys didn't know about. Glanville was there, ADA Love, Hilton, and members of Fulton County DA's office was there, as well as Copeland and his attorney. No member of the defense was present there. Upon information and belief, no member of the defense was aware that the meeting was happening. Sometime between 11 and 11:30, he takes the bench and announces Copeland will testify. So magic. How did that happen? Well, we're going to find out. At that time, Steele, Counselor Mr. Williams, inquired of the court, what the heck's happening? And that inquiry was not accepted. Copeland briefly testified. Then the ex parte meeting, the morning of June 10th, Copeland announced that he would invoke his Fifth Amendment. So this is what happened in the ex parte meeting. He would invoke his Fifth Amendment right. He stated that he would sit in jail for 2 years rather than testify. Glanville informed Copeland that he could keep him incarcerated until additional defendants were tried, not just these 6. ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Glanville took coercive actions in conjunction with one or more of the attorneys from the DA's office. So then Copeland stated at the ex parte meeting that he would testify.
Oh, hold on 1 second. I forgot a song. I mean, this is a mess. Oh, I can't do that no way. This is awful.
Glanville also presented Copeland with the printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. In Glanville's chambers, Copeland stated to ADA Hilton that if called, he would lie.
Now he said he would lie. Why do you need him and you got other witnesses? It's crazy to me.
DA Hilton stated she would not prosecute him if he were to lie on the stand. Then he said,
Then you stand. The prosecution said will not prosecute him if he lies on the stand. Any way to get Young Thug and his organization and his gang YSL. I have never heard of such a thing, but this is what we do when we have a little bit of power. It's shameful. It's shameful. And if y'all watch that case, your mouth is just going to drop. I have never seen anything like this before.
He would say he committed the homicide against Donovan Thomas, and Hilton said she would prosecute him for perjury if he testified that he committed that crime. And when one or more of the above allegations were presented to the court, Glenfield denied that one or more of the events above relayed to him were accurate. Okay? So that's just the full affidavit there. So what were you going to say?
All right. You step back and you kind of look at a big picture on this. First off, remember the ADA, the perjury, that there's a lot of facts in this affidavit that Steele did not mention. So you have to ask yourself, were there additional conversations after Steele was held in contempt that revealed other things that went on in this meeting? So that things that Steele didn't know when he made his original motion, because I'm sure he would have mentioned this in his original. I mean, this is dynamite. He would have mentioned this in his original motion for mistrial.
Well, if you remember, the judge was trying to make sure he didn't say facts, and he was trying to shut him down and stop him and saying, before we get into any of the facts, tell me who told you.
Right, but Steele, he wasn't very successful. Steele still was making his record as to what he heard. And
I feel like when I heard it the first time that he had more information than he was sharing personally. That was my...
Just like what I said, if the judge does not recuse himself or the appellate court makes him recuse himself, this should be a mistrial. If not, on appeal, he coming home. Welcome home, Young Thug. You got a hell of a lawyer, Brian Steele. And they even taking up for the hostile witness, because he is hostile. Man, I have never seen the buffoonery in the courtroom before, ever. And then Copeland also told the district attorney she stinks. She need to go wash up. Where they do that at? Where do they do that at? You can't make this up. All right, like, share, and subscribe. Watch that court so your mouth can drop. It's all day, every day. We on 7 months. Thank you.